but through an accommodation with the Senate Judiciary Committee, to allow us to gain access to other documents to which we would never otherwise be able to have access. They have agreed to hand those over with the understanding that we have this committee confidential process and that there are means by which we can clear documents like this one that we would otherwise not be able to clear. It worked here, it's been cleared, and I think we should move forward. Thank you.
Mr. Chairman.
Senator Durbin or Senator Feinstein, whichever one wants to go first.
I'd defer to Senator Feinstein.
Well, I will accept it. Thank you. It's my understanding that by agreement with private lawyer Bill Burke, the chairman has designated 190,000 pages of Kavanaugh's records committee confidential. And by doing this, Republicans argue members can't use these documents at the hearing or release them to the public. Unlike the Intelligence Committee, and I've been a member for about 2 decades, the Judiciary Committee doesn't have any standing rules on how and when documents are designated committee confidential. Previously, the Judiciary Committee has made material confidential only through bipartisan agreement. That has not been done in this case. So this is without precedent. Republicans claim that Chairman Leahy accepted documents on a committee confidential basis during the Kagan administration. It's my understanding that those documents were processed through the National Archives, not private partisan lawyers, and Republicans agreed. 99% of Elena Kagan's White House records were publicly available and could be used freely by any member. By contrast, the committee has only 7% of Brett Kavanaugh's White House records, and only 4% of those are available to the public. No Senate or committee rule grants the chairman unilateral authority to designate documents committee confidential. So I have no idea how that stamp, committee confidential, got on these documents. I sent a letter on August 10th, 2018, objecting to the blanket designation of documents as committee confidential. I offered to work with the chair. He refused. Judiciary Democrats sent the chairman a letter on August 28th, restating the objection to the chair's designation of the documents as committee confidential and requesting public release. As I've looked at the documents that are committee confidential, they do not affect any of the usual standards that would deny committee confidentiality. And Mr. Chairman, I think that's a problem. I think we're entitled to all records, and I think the public is entitled to all records that are appropriate and do not put forward personal information or information that otherwise should not be disclosed. So I do think we have a problem, and I think for the future we ought to settle that problem with some kind of a written agreement between the two sides, whether that's an agreement between the two sides of the entire committee or between the chairman and the ranking member. I think it doesn't matter much, but I think the fact is that we should agree on who determines something is committee confidential, what the criteria are for, and the release to the public, and particularly in the event of a Supreme Court hearing.
Senator Durbin.
Thank you, Mr. Chairman. And like my colleague, Senator Whitehouse, I don't want my silence to be interpreted as a consent to the process that we've faced before this Senate Judiciary Committee. It is unlike any process I have ever seen. This designation of committee confidential should be put in historic context. There will be an opportunity for us later this afternoon to meet in confidential and secret private session to discuss this nominee. That is not unusual. It is done for virtually every nominee. Some of the meetings are literally last a matter of a minute or two, and we say there's nothing to talk about, and we're leaving. but it's happened in the past. But whenever we dealt with committee confidential, it was something that was very specific and usually very personal to a nominee. And it was done by bipartisan agreement that we would protect the nominee from assertions or comments that may not have any truth to them whatsoever, but the committee should take into consideration. That is a far cry from what we have faced with this nominee. I cannot understand, and I said this on my opening statement here, the authority that we have given to a man named Bill Burke, a former assistant to the nominee, that we have said to Mr. Burke, you will decide what America gets to see about Brett Kavanaugh. You will make the decision as to which documents we will be allowed to discuss openly and publicly and which documents we cannot. Who is this man? By what authority could he possibly be denying to the American people information about a man who is seeking a lifetime appointment to the highest court in the land? The National Archives is usually the starting point of this process. I put in the record yesterday a statement from the National Archives disavowing this whole process, saying this is not the way we've done this in the past. We usually initiate this. Please give us a few weeks to do it in an orderly way. But the decision was made by the White House and the administration not to go down that path, not to take the same course we have on previous nominees, but instead to allow to this gentleman, Bill Burke, a private attorney, the authority to decide what the American people can see about the background of Brett Kavanaugh in other capacities. Who is Bill Burke? All that I know of him is that he was once an assistant to the nominee. I am told that he is not only the attorney for George W. Bush, but also for the White House counsel, Mr. McGahn, Mr. Priebus, the former chief of staff to the President of the United States, and Steve Bannon, a man whom I couldn't characterize in a few words. But he's his personal attorney. And in this situation, he is now the litmus test. He's the filter to decide what the American people will see about this nominee. And that's why we bring this issue before you. Lest you think we're carping on a trifle here, we are talking about whether the American people have the right to know. And we now know that less than 10% of the documents reflecting the public career of Mr. Kavanaugh have been made available to this committee. And I just want to say to my colleagues, and particularly my colleague from New Jersey, I completely agree with you. I concur with what you are doing, and let's jump into this pit together. And I hope my other colleagues will join me, so that if there is going to be some retribution against the senator from New Jersey, count me in. I want to be part of this process. I want to understand how Bill Burke, this private attorney, has the right to say, as one of my colleagues mentioned, this should be considered a classified document, a top secret document, a document that relates to the national security of the United States. By what right, by what authority can Mr. Burke possibly designate a document as committee confidential? He has no authority to do that. He only has authority because he has the consent and the cooperation of the Republican majority on this committee. That is the only thing that brings us to this moment. And let me just say in closing one last thing. I am sorry that one of my colleagues has characterized all of us on the Democratic side on the first day of this hearing as contemptuous. I have never heard that said before in a full committee meeting, but it's been said. And I'm particularly sorry that he singled out one of our colleagues on this side and accused him of conduct unbecoming a United States senator. I think statements like that are personal, they are disparaging, they question the motive of a colleague, something that we should do our very best to avoid in the United States Senate if we're ever going to restore the reputation of this body.
Mr. Chairman.
Mr. Chairman?
May I make just a brief point? Mr. Chairman, I'm looking at a Wall Street Journal article back during the Elena Kagan nomination. It says, document production from Elena Kagan's years in the Clinton White House. Counsel's office was supervised by Bruce Lindsay, whose White House tenure overlapped with Ms. Kagan. Bill Clinton designated Mr. Lindsay to supervise records from his presidency in cooperation with the National Archives and Records Administration under the Presidential Records Act. So President Bush, by choosing Mr. Burke, is doing exactly what President Clinton did in choosing Bruce Lindsay for that same purpose.
Mr. Chairman?
Senator Corona was first.
I thank my colleague. Count me into, Mr. Chairman. I too refer to a so-called committee confidential document deemed such by one Bill Burke, and we all know who he is at this point. And had the nominee asked me for a copy of that so-called committee confidential document, I would have been happy to release it to him or give it to him. I am releasing that document to the press, and I would defy anyone reading this document to be able to conclude that this should be deemed confidential in any way, shape, or form. Thank you.
Mr. Chairman, I know you've mentioned a number of times that I went through the process. I do want to point out, however, that I also was on numerous letters asking for all these documents to be released, and that my colleagues have repeatedly asked for documents to be released. And I go back to what happened on the first morning of this hearing, and that is that we pointed out that when there are 42,000 documents that are dumped on us on one night, there is absolutely no way people are going to be able to adequately review them. And as they review them, they're going to find documents that they want to be made public, that they want to ask the nominee about. So the whole point of this is because this hearing was ramrodded through, and we weren't given, say, maybe the month it would take to look at these documents, we are where we are. So my remedy for this, in addition to making it clear that I join my colleagues that we support what Senator Booker is doing here, is that you must somehow expedite the review of every single document, and we must have some kind of rules in place to get them out. I understand you'd want to take out Social Security numbers and things like that. That's normal. But we simply cannot hide these documents from the American public. It is the highest court of the land. And I was looking back at, everyone was citing people, the founders of this country, and I found a quote that really works here by Madison. A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy. That's what we're talking about here. By ramrodding this through for political reasons, by denying us the access to the documents, we're denying the public the right to see what's out there. And it's just not how we do things in my state, and it's not how we've done things in this committee.
Mr. Chairman.
I'm going to call on Senator Lee and then you, but before that, a couple things she just reminded me of in her comments. Number one was to take care of all the people that didn't act promptly like you did, Senator Klobuchar. That's why we extended it and gave the courtesy of doing whatever anybody else wants now, and those can either be brought up now. Those that you've got can be brought up right now to him, and the things that aren't cleared that you want to bring up with the judge, you can bring up in the closed session today. And the other thing is, when you talk about getting all the documents, I don't know who might work for members of this committee sometime, want to be on the Supreme Court, and for instance, we didn't ask for all the documents that Kagan had and emails or whatever communication she would have had when she worked with Senator Kennedy. Would you want to be exposed to that sort of thing? If you want everything to be made public, or all the emails that you have, whether I think they're protected for 50 years for United States senators. So you're talking about the public right to know. Do you want to give up your emails right now? Make them public? I don't think you do. Senator Lee.
First of all, Mr. Chairman, I want to say I'm deeply sympathetic to the frustration people feel when they don't have access to documents they want. As a United States Senator, I've faced this on a number of occasions. There have been times when we've been called upon to vote on legislation literally at the midnight hour, sometimes much later than that we haven't seen until moments before it was voted on. There have been other times, and I kid you not, when I've been asked to vote on a piece of legislation that has an annex to it, and I'm told that I can't see the annex to the legislation because it's classified, and it's classified in a way that I don't have access to because of a committee assignment that I do not have. It's incredibly frustrating. In those circumstances, we look for a demon. There are demons in those circumstances. They are too numerous to name here. In this circumstance, there is a demon, but that demon is a law of our own creation. It's called the Presidential Records Act.